private student loans are really just old debts in disguise. So don't be taken back by the explanation of what a student loan is. It's nothing more than an old debt, and you'll see student loan creditors have hundreds of thousands of lawsuits out there, and they're easy as pie to beat. There are several articles making up the deposit and sale agreement. Inside that agreement is the death of this lawsuit, is the standing killer. It's what kills this case in every case in the US. In all 50 states, what I can tell you is a case killer. If you have this, use it to win your case. If you join up for Killdebt.com, I'll give you that. I'll even throw in a coupon code for 10% off just to sign up, but that is the case killer inside their own documents. So I hope you go check out Killdebt.com for the case killer and standing killer that should win you this case. Hey, Brian Parker here, doing a video outside. Kind of warm, but very breezy. Might get blown over soon. Hey, this is Brian Parker with another interesting video. This one is about how to beat a student loan. Now, student loans, private student loans, are really just old debts in disguise. So don't be taken back by the explanation of what a student loan is. It's nothing more than an old debt, and you'll see several people have their hands in the ownership pie without anybody pulling away a plum, whatever that means. Private student loan creditors have hundreds of thousands of lawsuits out there, and they're easy as pie to beat. Specifically today, this is brought to you by a new member who has an NCSLT case, or National Collegiate Student Loan Debt. And again, it's just change the word NCSLT and change it to MCM. It's the same effect, easy as pie. The CFPB has found a lot of problems with the National Collegiate Student Loan Trust. There were 800,000 of them at one point filed, and they looked hard into what NCSLT was doing, and they required them to pay $2.25 million to redress some issues that I've seen for years. But that was in January 2025, and right before the deal was done, where NCSLT is going to have to fix the problems it's causing in its chain of title and sign with the government, the CFPB. April 28th, the Trump administration scooped in and pulled the deal. So this video is more important than ever in doing what the government can't do, or couldn't do, or no longer can do. Yes, you can. Yes, you can. So this is a YouTube channel, free site, free channel. I give you tons of, I think I got 650 videos on this channel. I'm gonna show you a killer way to win these cases if you're a member. So I just wanna be upfront about that. I'm gonna give you a bunch of free stuff like I always do, but there's one thing that I found when I started litigating these cases. I was litigating probably 15 years. And I finally strayed upon, as what always happens if you read things constantly, I found the killer document that wins these cases. If you remember, I'm gonna show you how to do that. But for the next couple of minutes, I'm gonna give you some free stuff on how to handle these cases. So this particular case a member brought me was filed in Michigan. Let me show you why it's so similar to many other bad debt buyer cases. Shazam. So that is your average debt buyer. Now, I file cases against this law firm with other plaintiffs, not just National Collegiate Student. It's the same complaint they use. One size truly fits all. But let's take a look at how bad this is. So if you were to look at paragraph 2, and by the way, you're gonna see this in your own cases, whatever state you're in, there's just no effort there. And that's where you come in. Make a little effort. It's 100% more than they're doing. So look at paragraph 2. The defendants, look how general that is, no name, entered into a contract for a student loan with plaintiff's assigner, Union Federal Savings Bank. And that's a made up account number that is like 2 assignments down the road. So for that to be true, Union Federal Savings Bank to be the assigner of plaintiff, National Collegiate Student Loan Trust, which we're gonna say NCSLT, has to assign it to them. So let's look for that. And then number 4, I find this so much. The contract was duly assigned in the normal course of business, all these commas, to plaintiff. There's no evidence of this, and I will tell you there were 2 pages handed to my member who got nothing else. There was no documentation. But she had seen my video about what to do with a pending lawsuit. Like, you know, a lawsuit is on its way because you've followed my instructions and checked out the court records. And she went and looked at the how to fight a collection lawsuit before it is served. It's all about garbage time. And what I preach is when they file a lawsuit, you'll see in the court document, doesn't mean you're being served. You're not in jeopardy till it is served. And in between that time, that could be up to 2 to 3 months. That's garbage time, but it's time that you can use to pepper all the people in the chain of title, whoever claims they own this, with letters and a pursuit of dispute validation before you're actually served. And that's what this member did. And it's a good thing too, because what you saw in that complaint, that 1-page complaint, it was all she received. There was no proof behind it. Again, they were claiming plaintiff's assigner, that must be the guy that gave it to them, was the creditor, Union Federal Savings Bank. And you'll see that that's not true. So the why I preach about garbage time, and this is so true here, you're gonna be sued, let's say. You know it's been filed, but it's gonna take a while to get served. You send your letters or validation requests to whoever, and what comes back contradicts the actual paperwork sometimes of the lawsuit you served. And this is the case here. In the lawsuit, they're saying Union Federal Savings Bank was the assignor of the plaintiff. We're gonna see that's not true based upon this member's using garbage time. And the contract was duly assigned in the normal course of business. There's no proof of that or what that means. Try to figure out what in the normal course of business means. It's general for a reason. So when you're tackling this kind of case, the first thing you're gonna do, and this is not a hard task, is look up your statute of frauds in your state. In Michigan, where this is filed, it's a good one. So we have a statute of frauds video, Shazam, and that is a general education for you. By the way, all this video is done for educational purposes only. Like, love, and subscribe, and share. But these are all debt buying cases where the chain of title is always in question. So when the member did her validation request in garbage time, she received this letter and a chunk of paperwork, Shazam. And that is essentially 2 things. Your dispute has been deemed invalid at this time. I wish you could just say that about the complaint because it has such emptiness. And number 2, the documents attached are being provided to you to validate these debts. Well, it's either her dispute is not validated or it is, but they gave her a bunch of documents in garbage time that will now contradict the actual lawsuit that they eventually serve her with. So the original loan documents are the first place you go. And so when I say the first place you go, in your case, you will see all these same papers generally in whatever state you're in, okay? One size fits all to them. Shazam, and that's your first document that you usually see with these things. Now, the complaint says the contract's in the possession of defendant. This is almost 10 years later. That's rarely true, but then they have the contract all along. Why didn't they just attach it to the lawsuit? I don't know, but that's it. And it's a basic loan request credit agreement. A bunch of banks got together, Chase Bank, Bank of America, this bank, and produced tons of these loans that would eventually get securitized and end up today with people being sued almost 10 years later on debt that's long gone. But the important thing is I want you to look at the second page, Shazam, and if you look at L, it says additional agreements. I understand that you're located in Rhode Island. That's where the bank is, and that this credit agreement will be entered into in the same state. Consequently, the provisions of the credit agreement will be governed by federal law and the laws of Rhode Island. Remember our governing law videos, Shazam, lots of them, you've heard me say. So what you do, you go, here's the state I'm in, here's Rhode Island, and you look at the laws of both states and which one favors you most. If it's Rhode Island, you make noise. Hey, the contract that I'm being sued for breach of contract says supposed to be in Rhode Island. If it's in your state, you be quiet about it. They sued you in your state. They have the burden of proof. So always check out your governing law. Let me put that up there, Shazam. And that's what you look for in all of these agreements, in these cases, in your case, whatever state you're in. Again, it says, I understand you're located in Rhode Island, following the laws of Rhode Island. So these always have a broken chain of title because there is no proof. And they supply with you 2 batches of documents. The first one's a pool supplement agreement. Let me put it up. This is 2007-2 for Union Federal Savings Bank. That's your basic beginning of the pool supplement. All right, that's where she received her garbage time paperwork. Remember, the complaint said, let's put paragraph 2 up there again, Shazam. Plaintiff's assigner was the bank, and that's it. There was nothing else. Yet the garbage time paperwork says, wait a minute, Charlie, there was a pool supplement wherein it says First Marblehead Corporation and Union Federal, you should see it up there in yellow, Savings Bank, the program lender, and the purchaser here had a contract. It's called a pool supplement. And the depositor, is the National Collegiate Funding. That's a corporation, a limited liability company that will in turn sell the transferred loans to the National Collegiate Student Loan Trust. So there's a bunch of assignments going on there is my point, and nothing is mentioned in the complaint. Like the complaint says that doesn't exist. So it then goes on to say the depositor, which is the National Collegiate Funding LLC, hereby purchases said notes, and those are supposedly the debts, one of which supposedly without proof my client is in, and that depositor sells them to the National Collegiate Student Loan Trust with this First Marblehead Corporation. If you're sitting there going, oh, wait a minute.
Say, hold up, wait a minute, something ain't right.
You should be, because how are you showing to court all these things in that very limited complaint? Limited is very nice to say. So there is another document that's always attached to these cases. It's the deposit and sale agreement. These documents generally are accompanying any securitized trust, whether it's Citibank or any other creditor that's dumping its stuff into a trust. They are accompanied by the deposit and sale agreement, the pooling and servicing agreement. And that's great stuff to investigate, as I'm showing you here. In this case, the deposit and sale agreement, this is between the National Collegiate Funding LLC and the National Collegiate Student Loan Trust, the supposed plaintiff in this case. Now, attached to it, they tell you to go to a loan schedule so you can see this specific member's debt. So that's what we do, Shazam. And there's Schedule 1, transferred loans, and that's it. There is no mention. It's just nonsense without any proof. So that's their entire schedule of debts. There are no debts there, essentially. There are no specific assignments. I'm going to try doing this by memory. So Marblehead Corporation hasn't assigned anything to National Collegiate Fund LLC. There's nothing between, I said I'd do it by memory. There's nothing between National Collegiate Funding LLC and National Collegiate Student Loan Trust. There's nothing coming off the original creditor, Union Federal Savings Bank, to anybody really with the member's name. Now, there is inside the deposit and sale agreement. So let me just put that deposit and sale agreement. So you see where it says Article 1? There are several articles making up the deposit and sale agreement. Inside that agreement is the death of this lawsuit, the standing killer. It's what kills this case in every case in the US. In all 50 states, what I can tell you is a case killer. If you have this, use it to win your case. If you join up for Killdebt.com, I'll give you that. I'll even throw in a coupon code for 10% off just to sign up. But that is the case killer inside their own documents. So I hope you go check out Killdebt.com for the case killer and standing killer that should win you this case. Thank you very much.